2017. This meeting was called as per board decision on the last regular meeting. And first we'll start with the call for quorum by the executive director.
Good morning, everybody. Mayor Tomás Regalado.
Here.
Commissioner Whittemore. Here. David Madison is absent.
Good morning.
Commissioner Keenan Hardeman is absent.
How are you? Morning.
Ms. Eli Feinberg.
Here.
Mr. Nathan Kirtland.
Present.
Mr. Dave Slosky.
Here.
Rachel Foster Wagner is absent. Mr. Luis Salon.
Good morning and here.
Rafael Cabrera is absent. Mr. Frank Veloso is present. We do have a quorum.
Okay, thank you. Let's give the approval of the minutes.
Okay, all right. It's okay.
On the last meeting, we were running on a deadline, and this is why this meeting was called for today. And precisely at the time that we said that we needed to have items discussed. One of them is a direction from this board to the city attorney of the city of Miami to analyze potential default of contracts of seaplane bays and heliport. We have the city attorney of the city of Miami here, Victoria Mendez. We have the deputy city attorney, John Greco, and of course we have our board city attorney. So, Madam City Attorney, you want to start? You want to?
Yes. Well, first of all, I want to start off by saying happy birthday.
Thank you.
Happy birthday.
Happy birthday, Mayor.
And second, we followed the board's instructions and we looked at both the contracts. And we have just certain information about each one. I think Mr. Wyson can elaborate on what we did find and.
Yes, thank you. The city attorney's office met pursuant to the instruction of the MESA board. I called in a contract attorney as well as a commercial litigator. And the executive director was an essential component of that meeting. And the four of us sat down and we went through both agreements. And we discussed with the executive director any concerns or considerations that she had that could potentially result in a default. And we went contract by contract. We also looked at other information that she had received from outside sources. And it was our conclusion that at the present time, there were no actionable default items for either contract. We didn't want to obviously put something in writing indicating defenses for either party in the case that times or circumstances change. This is a moment in time assessment, and what it means is that they could come into default in the future. But as we looked at it now, pursuant to the board's instructions, we didn't find a default. And if there's any questions, one issue I wanted to know is that there are a few new members to the board, and I was wondering if any of the board members do not have a copy of the development orders or the contracts, please let us know. We'll provide them to you so you could look at them as well. And any information you need, feel free to contact us. If there are other issues that concern you, please contact us and we will investigate them. We are constantly looking at the contract to ensure compliance with it. So that's what sort of made this a little bit easier, is we had an ongoing compliance sort of review, and that's where we stand.
If any board member has any questions to George or the city attorney or the deputy city attorney, but I just want to clarify something, George. You just said that those contracts, something could happen that could be in default. What are those things?
Well, for example, like a late payment, that constantly the issue we monitor is whether or not the payments are received on a timely basis. An issue arose, the executive director brought up the issue of the payment performance bond for any construction done. In reviewing that information, the city follows the Florida statutes, it's 255, which says, basically, if you're a government entity, a contractor can't go after you for a mechanics lien because it's publicly owned property. So the state of Florida adopted what they call the Little Miller Act, which protects contractors and creates a scheme where up to $100,000 worth of contracting, a payment performance bond is not required. 100 to 200, one may be required upon the direction of the local governing body, and anything over 200, it's absolutely required. The city's position is that we've always required it, anything over $100,000. So the work that had been completed on the various sites did not reach that threshold amount. The other issue was that the work had already been completed. There was a paving permit that was final, so there's no way to call them into default at the present time. There were issues of late payment we addressed. Plans. An issue arose as to whether or not the heliport had provided plans to the MESA board in accordance with the agreement. And remember that the heliport agreement calls for a phased construction schedule. Phase 1 is the pads. Phase 2 is the fuel farm. And phase 3 is the whole project. If you look at the contract between MESA and Linden, there is a plan attached to it. And the executive director at the time of MESA approved the contract, the city commission approved the contract, and so this board has approved the plan. Now, what that means is that's a plan, like Nacho and Chalks is going to present a preliminary plan. It's a preliminary plan. When you speak with the building professionals, they will say that is clearly not a building plan, that is approvable or acceptable, because you need the full set of drawings and all that stuff. But it's a conceptual preliminary plan. So Linden has provided that, it's part of the development agreement. It's attached to the contract as an exhibit. So that was one issue that was resolved. And the insurance was an issue that had arisen earlier, and we received the certificates of insurance showing not only is there insurance, but they actually got extra insurance, at least as far as the heliport. Chalks has always been in compliance with the insurance. They've always been on time with their rent payments. So those were the various items that we looked at.
Is there any issue about timelines in the contract?
Yes. All right. So which one do you want to discuss first? Whichever. All right. I'll start with Chalks. Chalks contract says that they have to submit a set of preliminary plans, and upon the submittal of preliminary plans, upon the written approval of the plans by this board, then they have to submit the real plans to the building department. Upon their approval, they have, I believe, 18 months to begin complete construction. And then the contract, so the issue is, or the pending issue with some administration individuals is that while the agreement says they had to submit their plans upon the effective date of the execution of the agreement, and there was a period of tolling on that, they had to submit their plans. They've submitted their plans. The contract is relatively silent about what happens if this board rejects the plans. The contract doesn't provide a time that says upon rejection they have so many days to submit another set of plans. And so that's what sort of led to the limbo and the frustration. But the board should be aware that there's a provision in the contract that says that the seaplane base must be completed and in continuous operation within 3 years of the date of the rezoning. The rezoning occurred in January 28th of 2016. So that means by January 29th of 2019, the seaplane base needs to be fully completed. So that's their hard deadline.
Any deadline for the heliport?
The heliport, as you may recall, the issue with the heliport was the license. And so they had a certain amount of time to come forward and begin and construct phase one. They ran into the issue of the license. And so we had many months of determining through FDOT and FAA how we were gonna get the heliport an airport license. And so this board made a motion that until that license is resolved, that the timeframes for Linden's completion of its project are told. So the question of the day is whether Linden has been working hard to get to that point of getting the license in conjunction with the city. And so, once they get the license, that then allows two things to happen. I'm sorry, let me rewind. First thing that has to happen is they need to get the exception from the city, the planning department, and zoning department. That then allows the city to let FDOT know that the heliport facility is approved. They can then finish up their regulation and their approval or denial of the heliport site. It also allows Mr. Dudley to then submit his plans and begin construction of phase one, phase two, and phase three. So it's sort of, the linchpin is the exception at this point. So that's where we're at with the timeframes.
Any questions from the board? The city attorney? Any questions? Francisco Garcia, planning director, zoning director.
Thank you. Just for clarification's sake, yes, thank you. Just for clarification, Francisco Garcia, planning and zoning director, for clarification's sake, and to go a little bit more into a fine-grained view of things based on what Mr. Wysong has stated, the exception permit is granted ultimately by the Planning, Zoning, and Appeals Board through a public hearing, not administratively by the Planning and Zoning Department.
So is there a timeline after he receives his license for the heliport, similar to the 3 years at the seaplane?
Well, his is more an in-progress timeline, that there has to be a completion, within so many days of getting the building permits and stuff like that. So he doesn't have the global 3 year, he has to meet the time frame.
It's our understanding that phase one of the heliport's already been completed with the, is that correct?
It can't, phase one can't be completed until they get the exception, right? Because that leads to, part of the building process is you do your mechanical, your electrical, all the different trades. One of those trades is zoning. The exception gets them the zoning approval. They can't get a CO or a CU to operate the airport facility until they get that exception. So that's why I say that's sort of the linchpin.
I mean, but similar to what you said, it's based on his speed in getting, it's all based on his willingness and how quickly things get done. There's really no penalty per se or anything that says, hey, we need to do this in 6 months, 12 months, 18 months.
Right, and as you've lived this, you've seen the difficulty in getting a clear answer with the FDOT and FAA, and then there was a minor setback regarding whether a warrant or an exception was required. We passed that hurdle, and so there is progression. But obviously, your concern is that they're progressing fast, with all due diligence.
And the final question, in the future, if there's late payments or anything that is, default for the contract, Lourdes should not accept any checks that are late or anything that could put the contract in jeopardy.
Well, and these contracts are relatively generous to the people who receive the contracts. So there are default provisions, and the default provisions provide for a cure. And so when we look at whether or not, if the check is a day late, they have a certain amount of time to cure and all that. Then we have to put them on notice and all that stuff. So we are constantly on top of that. And Lourdes lets us know as quickly as possible when a payment is late or if somebody doesn't pay a performance bond or something like that. So, but it does require diligence on the executive director's part. And so we've committed to answering her questions anytime a potential default has arisen.
Jay?
Mr. Wesson, isn't there a non-waiver provision in the leases, so if we would accept a payment after default, it doesn't waive our rights to assert that default?
I believe so, but so long as the payment, the actual payment is tendered within that default cure period.
Mayor, we all got renderings this morning from Mr. Dudley on the design of the heliport, and it's a beautiful design, but it's several stories, at least 3 or 4 stories, and it's based on parking. And there's some question in regard to the possibility of the city changing the zoning request on parking at one point and coming up with a new plan now. Is that the case? Is that the reason why they need this adjustment?
Well, like I said, so if you've seen the drawing, I might have a copy of it somewhere, of the preliminary plan, it just shows a hangar facility, the 4 pads and all that. But that, like I said, was a preliminary plan. So then when they go to zoning and they request their exception, zoning of course looks at, you're gonna have a restaurant, you're gonna have a heliport. Whatever uses that you have, there's attendant parking requirements and perhaps green space requirements. There's a slew of requirements that they have to follow. So in addition to those, you have, and I'll let the planning and zoning professionals speak to that, but in addition to that, there's issues of setbacks from the water, setbacks from the property lines and all that. So if you have a huge parcel, you can just use a surface lot. But if you have a tight, narrow parcel, then you have to provide the parking in another manner, which usually means you have to go up. And so that's one of the issues. And I'll turn it over to planning or zoning.
I think by way of introduction and for your consideration, since we have, so for your consideration, it serves the board's mission well. What I would say preliminarily is that we have literally just received the drawings you are now seeing. I believe the email I received at least came in this morning at 12:15 a.m. And so, as Mr. Weissman pointed out, there are a number of requirements having to do with heights, massing, with scale, with parking, with open areas, etc., that we have not been able to examine in detail. I would posit that the renderings presented are rather compelling as heliports go. But again, there is a rigorous analysis that has to take place to vet whether this would be allowable or not pursuant to the applicable zoning regulations. So that is really as far as I would want to go based on the information that we have at present. If there are specific questions that you would like for us to address, we're happy to do that.
So this is just a wish plan?
At present, until vetted, yes.
Okay.
And I just wanted to clarify too, that as I indicated, attached to the contract, there's a plan, a rendering. So that obtained MESA approval. When the fuel farm comes along, that will require MESA approval. And when the ultimate construction is presented, that will require MESA approval. So the contract calls for MESA approval for each construction phase, if you will.
Mr. Fernandez has been
Thank you, Mr. Mayor.
recognized.
Ben
You
Fernandez.
need to get the microphone for the purpose of recording.
Thank you, Mr. Mayor. Ben Fernandez, joined by Mr. Richard Obelman on behalf of Chalk and Nautilus Enterprises. I just have a point of clarification. There was mentioned by Mr. Wysong of a 3-year period that commenced at a certain time that related to the rezoning of the property. However, that is not the accurate trigger. The rezoning that was required was discovered after there was a meeting of the minds with respect to the lease. It was required because Miami 21 inadvertently rezoned this property, and it was discovered that we needed to rezone it in order to make the seaplane base consistent with the zoning. So the trigger that begins a 3-year period is the exception process, which is what allows us to move forward with the development. And I just wanted to clarify that for the record because that hasn't taken place yet, and that's a significant milestone. And I would like the department to confirm that that's the case to the board, either the zoning administrator or the planning director. The exception is what allows the use to be permitted.
I can only respond by saying, in paragraph 1.14 of the Chalks agreement, it refers to tenant improvements. In the middle of the paragraph, this is what it says. Tenant shall complete construction of the tenant improvements and begin continuous operation, as defined below, of the required minimum operations, as defined below, no later than 3 years from final, non-appealable approval of the required rezoning of the property, the construction default date. So it doesn't talk about exceptions or warrant approvals, it refers to rezoning. And if your argument is that the contract was improperly drafted and should have said zoning approval or something like that, but it used the term rezoning.
The required zoning, that term, is the ability to use the property for the intended purpose. In this case, because of the zoning classification, it is impossible to utilize the property for anything until the exception is granted by the Planning, Zoning, and Appeals Board. So the term rezoning there is meant to encompass the exception approval, and that has not taken place yet. So the 3-year period has not commenced yet. That's my point for the record. Thank you.
If I may, I guess I'm the only sitting elected official that participated in the Miami 21 project now. Francisco, you may remember, this was done 2008. I remember that part, you know, the north part going to the beach was on a little part, and the rest was on as required by Miami 21. Is that something that is correct?
That is correct, yes.
So Mr. Fernandez is saying that there is no, that the 3-year window doesn't exist.
That is a legal issue. I'll defer to the city attorney's office. I would posit, once again, for the record, that the zoning certainly is in place presently, and it only allows for the use that is requested and considered, and also facilitates the use that is requested and considered. Beyond that, I'll defer to the city attorney's office.
And we have all faith and confidence that the project will be completed prior to the 2019 date, but if it isn't, then we will obviously address the issue then.
But I would like, sorry.
Excuse me, just,
But
you
I
will
would
be
like-
recognized, but just to, the message to what you're saying to the board is that we just don't know if the window exists. You believe that exists, but then if it doesn't happen in 19, then the city attorney's office will deal with it.
It has a 6-month, there's a provision that says they can appeal to the board for an additional 6 months, and then that would be it. So that's our position now. And it makes sense because otherwise the contract would create a situation where they could submit a plan, it'd be rejected, submit a plan, it'd be rejected. You know, there is no end date, so that's why we think it makes sense.
Mr. Bailey?
Yes, and I don't think we can leave this for a future date when we have the problem, but I think it's fair to say everybody at least what I think, and what I think is what just Ben Fernandez said. But I would like to refer as well to a section in the contract that says, notwithstanding anything to the contrary in this sublease, tenant shall not be obliged to submit any preliminary or final plans, nor commence any construction, and any requisite time periods for completion of construction shall not be triggered absent a rezoning of the property to permit tenants' uses. And the exception, and when you are required to go before the exception process, you are not authorized to do any use until that exception is placed. Thank you.
Let me ask a question. We've been at this for a while, and I think we have come a long way. Is there any way that we can get everyone together, so we can get this expedited a little bit?
I believe, and the question has come from both the developers as well. So we've had joint meetings where the professionals have come in, and we think that's based upon the recommendation of the mayor and the board, and we think that's healthy and should continue. You can hear from from the professional planning staff. From my perspective, it appears as though they've been working hard, they've been meeting with the planning staff and the zoning staff to move this forward. There is always a sort of lack of coordination and communication that can be solved by these meetings, so yes, I think we can all work together to move this along.
I think we need to do that. We've been going at it for a while now. Maybe one department will make a statement, then the different department will come up with a different idea, and you gotta bring all the minds together.
So if we were to write a headline tomorrow, the headline would have been, what George said, they have to finish by January 2019, but I guess technically they don't have to.
Well, so, reading the agreement, alright, so once this, you all approve the preliminary plans, assuming you approve the preliminary plans on the next agenda item, that triggers, dates. And so within that, the 3-year period should have been plenty of time to actually construct and continuously operate it. And I believe that the Chalks team has indicated that they are desirous of opening up their facility as quickly as possible. So I really don't think that's an issue. The only reason I brought that issue up is there was a lot of concern that we were sort of in limbo. So I wanted to say that there is a sort of stick at the end that required, which we may have to resolve, but our view is, and as that provision that Nacho read, and you contrast that with what Francisco Garcia said. Francisco Garcia said the property is zoned so that they can do what they want to do. So our position is it has been rezoned and the clock has started. And there is no zoning impediment at this present time. There are regulatory approvals and processes that you have to go through, but that's not tantamount to a rezoning of the property.
Okay, so that's the city attorney's opinion. That's the opinion that we go to the plan from the seedling base that the board has to approve.
I mean, Mr. Mayor, for the sake of all, the summer's coming up, so we might not have a meeting for the foreseeable future, and I think we just would like to know the process for both the heliport and Chalks on what the next steps are when we have a meeting. We give them a certain direction, and they've completed that direction, because if not, we keep going around in circles and nothing gets accomplished. I mean, this is the first time we've ever received any renderings on the heliport. For us, it was just asphalt and
Right.
trailers,
But we don't know if
yeah.
this is approved.
Exactly. So I think we need to, if it's a license is the issue, if it's the building department, what are the things that have to come next with the direction of zoning, the city attorney? So that when we do meet again, they've had direction, they've completed it, or if we give them direction and it's not completed, is it an amendment that we have to make to the contract, that then it gets in default? We need direction from you guys to help us move this along, because there's a lot of events coming into the city of Miami. Heliport would be great. I'm under the opinion that that new condo on the downtown that's gonna have a helipad will be completed before this gets done. To be honest.
Actually, yes.
Yeah, so,
Actually, yes, it will be completed, on, the Zaha Hadid, building will be completed, in July, in October of 18.
and that's something that wasn't even on anybody's mind when this plan started, so.
And having been a city employee for many years, you often hear the conflict between the developer and the building department. My humble advice to any developer is that the city doesn't design your plan. We're not your architects, we're not your engineer. You should submit a set of plans to the city that the plans reviewer and planning staff should look at it and go, you got everything, here's your permit. And the city will do that and has done that. You hear from some developers who constantly blame the city. And the city administration gets a lot of grief over that. But oftentimes you gotta look deeper and see, maybe it's the architect or the engineer that hasn't done all their stuff that they should do. But then other times there are issues where it's truly complicated, like the unfortunate false start regarding the Warren permit and the exception. Set upon a path, we have to go back, go forward. We've cured that. We're working hard, and planning staff and zoning staff can talk that the developer, as far as the heliport, has come forward. His contractor is here, and they're I mean, I think you should hear from this planning staff to see if they are truly, working diligently. But if we get word that they're not working diligently, then we'll report that to the board and then give you the option, maybe you could remove a resolution or something like that.
So my main question is, there are pads there now. We've discussed having porta potties, trailers, whatever, to just start it running. What is needed for them to take off and land?
So here's
Yes.
and that's the difficult, interesting thing. For the pads,
Yes.
they need an exception. Just for the landing, takeoffs, operating heliports. For this glossy production, they need an exception. So when the developer went to the city, it made sense to say, why would you spend the time, money, and effort to get an exception for the slab when you could get the exception for everything? Bundle it up, do it all, city handles it everything. And so that relatively good advice is what sort of delayed it. Let no good deed go unpunished. And so I guess the developer could retack and say, all right, fine, forget the big glossy development. I'll just spend the time, money, and effort on the pads, get that operational. But it seems, and that's, I guess, ultimately up to the board, but it seems like that ship has sailed to a certain degree. So if they're close to achieving the ability to go to the public hearing to request the exception, then, so much time and effort and plans have been drawn, they perhaps should continue on that path. But, so that's the issue, is that an exception is required just for the pads, and an exception is required for the bigger thing.
But it could at the same time be two different exceptions.
It could be.
If you want them to start flying, they could put a porta potty, a trailer for an office, no parking is necessary, Uber, Lyft, whatever. And the most important thing here that they don't currently have is an FDOT license. Or an FAA license.
That's absolutely true. Yeah, so the exception is what gets you the zoning approval, which then allows FDOT to proceed forward and say that they can approve or deny the site as a airport landing facility. So the exception and FDOT are the triggers to opening up the heliport and operating it.
So is that what we want? Do we want them to have two different exceptions?
Well, we have to ask Mr. Dudley if he wants to comment on the suggestion. But it's always been the board's position that the heliport must be operational. And we for several meetings, we were discussing the porta potties and just the slabs and all that, but
Is that through planning and zoning, Mr. Garcia, the exceptions? Or is that through the building department?
no,
The important to know, because it's, both have been spoken about at some length, the building permit and the exception permit. In order to secure a building permit, ultimately, zoning approvals and planning approvals are required. And the zoning office and the planning office would not be able to issue their respective approvals until or unless the exception itself were approved. And as mentioned previously, it so happens that these exception permits are not ultimately granted by the Planning and Zoning Department administratively, I'll say it again for emphasis, but by the Planning, Zoning, and Appeals Board in public hearing. What we do in the Planning and Zoning Department is receive the application, deem that it is a complete application, sufficient for review, vet it for compliance with the applicable regulation, and ultimately review the design, etc. It goes through various internal boards, and then finally we make a recommendation to the Planning, Zoning, and Appeals Board, which they consider and ultimately approve or deny. Just to complete the cycle, that approval or denial by the Planning, Zoning, and Appeals Board can ultimately be also appealed to the City Commission. And so once that exception process is complete, then the building permit process can come to completion as well. They can run on parallel tracks, but it is then that we will be able to sign off. We administratively, the planning and zoning offices can sign off on the building permit, and that also say, to address the point previously made, that there is nothing preventing the applicant from applying first for one exception under a sort of an abridged version of the project, and subsequently for another exception for the full project. In fact, that might be advisable, but again, it's ultimately
That's a question
the
I wanted to
applicant's
answer.
choice.
Okay, thank you.
Ladies and gentlemen, Mayor, board members, there is no one who wants to get this going more than we do. When the question about penalty was asked before, we've got the penalty, we're paying rent, we're paying taxes, we're paying insurance. We've had full heliport insurance on it, even though we can't land, so we would be ready. We're very eager to get it going. There was some very good advice from Francisco, who I know 10 years, and from Devin. I know Cisco is an absolute expert on these matters. I've known him a decade. Devin has worked hard. The real issue is we banged into this problem of the zoning change. When the zoning changed, a lot of things changed, which were not anticipated in the contract. We're just trying to move the heliport forward. The problem with two exceptions, when the legal looked at this, is yes, we could do it, but there's no guarantee of getting a second exception. No exception is actually guaranteed. So if we get the first exception and we get open, that triggers the timelines in the contract for phase 2 and phase 3. If we have to go back for a second or third exemption, there is no guarantee that they will happen, which means we're automatically going to be in default. So that is the reason, ultimately it was decided upon the advice and counsel of the planning and zoning and others, that everything should have been done at once. Back in June, it was decided that we were told to apply for a warrant. That would be a 3-month process. 4 months into that, it was then decided that that wasn't sufficient, it had to be an exception. We had the heliport ready to land the end of September. We placed insurance on the heliport. We expected that by applying in June, we would have our exception by mid-September, get our license, be able to open. Rest assured, the heliport phase 1 in terms of the landing pads as prescribed in the original plan that Mr. Wyson alluded to was done. Then we got into discovering some things with Mr. Pons, who was kind enough to meet with us, where he said, well, I know it's not on that plan, but you need to have bathrooms and things of that nature. Fine. So that's the next thing we had to address, which was outside the scope of the original drawings that the city provided. So now the plan is that we will get, they call them, they're trailers, but they're strapped down to be temporary buildings and code compliant. We're in the process now of getting water out there. We already received a fire department permit to hook up to the water. So that when all of this comes together, we have the water, we have the electric, we have the trailers. What's holding us up right now is the zoning. And it's far more complicated than most people understand. I've gotten an education on it from these gentlemen. The reason the building is laid out the way it is, we want to build something nice and iconic. I hope you like what we're proposing. There is no space on the ground from the city's plan and the amount of property that they gave us for parking. Parking apparently really wasn't a big issue when this was considered. Miami 21 rolls around, it becomes an issue. So the only place we have to go is up. The original building we were planning was 2 stories plus the roof. We've added the parking. As you can see, if you look at this and you compare it to what's around it, I think this is a very nice building. I hope you agree. Nothing is set in stone. If you want changes, we can do it. But I think that this is a nice building. This is the goal. Now, to get to this goal is going to require a final determination on what we can and can't do for planning and zoning, and those adjustments will be made. We have, rest assured, we've done everything that we can do. We've filed everything that we can with the state of Florida, up to the point of stopping because of this zoning. So we were ready on time. We were ready ahead of time. We were ready mid-September. We didn't have to be ready till the end of September. And I hope you understand that we're trying to move it forward. There's no one in the room. I don't think there's anybody in the room more than I who wants to get this done. If you look at the pictures that we've given in front of you, we just tried to give you some idea of what it may look like in terms of the other buildings. The goal is to have a nice facility that functions like a real terminal. Where is it? And you can see from the pictures that we presented and from the larger boards that this is what we're looking to do. Now, whether we end up with 2 stories and parking because planning and zoning says, well, this is what you need to have, or an extra one, whatever it is, we're going to do what they dictate we have to do. We get that. We have not submitted building plans, as Devin very kindly pointed out at the last meeting, because you can't submit building plans until you have a determination of what you're allowed to build. And I hope everybody understands that. So we're eager to do this. I sent this out last night to the board members because someone pointed out that maybe not everybody would be attending. Mr. Carey is here today. He's from Kimley Horn. He's the city's engineer on the project. He's our engineer. He has been corresponding back and forth with planning and zoning. It's a very, very complicated issue, far more than most people would ever understand, certainly more than I understood, in the interpretation of the code, interpretation of the use, interpretation of the interpretation. So at the end of the day, whatever is resolved by this will determine what we're able to build. This is what we'd like to build. I hope you like what you see. I hope you like the concept. And if there's any questions, I'd love to hear them.
Yes, sir.
Mr. Dudley, I have concern with proceeding to get your exceptions at the same time. It has been the will of this board that we see the heliport working as quickly, as soon as possible. Now, proceeding for both exceptions is certainly going to delay that for some period of time. Let's assume over time.
You may be right. You know more about it than I do.
Let's assume over time that you get those exceptions and you have everything done that you want to do, and now you go to FDOT. Well, by this time, let's assume the 10 Museum Park building, Zaha Hadid, is done, and they are going to FDOT, and they are asking for permission for takeoff and landing of helicopters on their helipad. Would the existence of that license prevent, affect, or delay your ability to get FDOT to issue a license for another facility in such close proximity? Because if it does, then I think it frustrates the will of this board, because it will result in even a further delay once we get by the administrative process with the city and then get involved in a quagmire with FDOT over 2 heliports within close proximity.
It's a very good point to bring up, but that heliport, my understanding, is not a commercial heliport, it's a private use heliport. Okay. Our airspace was already approved. The city was required to get airspace approval by the FAA, and it did so. FDOT requires a thing called coordination between adjacent facilities. We've done, that would be done as part of that. I don't see that there is a conflict on that level. If you want us to proceed, this is more of a legal thing, and you're a lawyer. If the board wanted us to do it separately, I don't think at this point we're so far down the road now, I don't think it's necessary to bifurcate it. If there was an insistence that we do, there would need to be a motion, which you of course could craft, that would suspend the timeline for further phases contingent on receipt of the exceptions for those phases. Here's the concern. We get an exception for phase 1, we open phase 1. We now apply for the exceptions for phase 2 or phase 3. We only have like 18 to 24 months, whatever the number is, from when we go from one phase to the other. It is entirely possible that we could not be granted that exception for the second or the subsequent exceptions, or they may take a very long time. So there would have to be, if you want to do it, I'm in your hands, but if you want to do it, there has to be some mechanism to prevent this possibility wherein we get exception 1, we open, our clock is now ticking for our 2 and 3 phase. We go to apply for an exception for 2 or 3, either it runs out the clock on us, because remember, we can't build until we get it, or what happens if it's turned down and we end up in litigation. So I'm not sure that bifurcating it at this juncture is the best idea. If you would like to consider that, we would agree to it if there was some protection against either the eventuality of it being rejected down the road for 2 and 3, or the timeline's running out. I don't know if I'm explaining this clearly, I'm not.
You could proceed for your exceptions concurrently.
But there's no guarantee we're gonna get them.
You're not gonna get a guarantee if you put it together either, so that's not a guarantee. So you need to understand that. If that's your choice, that's what you wanna do, that's fine. But I think you have to get together with the planning department, make sure, I don't know if this can be built or according to, this is, something you presented to us. I don't think there's any architecture in here or any study, and whoever put this together, they should have met with the department and known what he could build there.
Well, let's go backwards, Commissioner. I mean, I've been doing this since '99, and I agree with you, but what's happened is, as Mr. Pons pointed out, the city almost works in silos, which has nothing to do with us, where the predecessor to Dream was property management. They were the ones that put this together, and they put it together under a different zoning code. It was put together really back in '99 and 2000, when I first started this with the city. So here we come fast forward, we're here today, we're applying today's rules with you know, Mr. Pons actually was quoted in a newspaper article in the Herald, and he put it very, very nicely, and I saved the copy, I have it with me, where he was talking about people were complaining about the increase in parking for Flagstone. And I remember your comment, pardon me if I paraphrase, but I brought it with me. It's the same project, but we have to look at it differently now because it falls under different zoning. So under the old zoning, you needed 1,400 spaces, and now you need 18. We're in the same trap of this, Commissioner, that this project has gone on for so long. You were along when there was lawsuits by the predecessor to Mr. Nacho, Mr. Vega, where we spent 7 years in litigation, 2 different lawsuits, and I'm just paraphrasing. So we got killed on that. Then the city gave the property to the state of Florida to build the tunnel for 4 years. And I was told I have to wait. Because I was awarded in 2002. Wait for all the litigation to be done, wait for the tunnel to give us the process. So all this time things have changed, Commissioner.
I understand.
Yes, sir.
So you wanna proceed, you're gonna get together with them, my understanding, you're gonna proceed with your plan, and they're gonna get together with you and try to help it to expedite it, correct?
Commissioner, there was a thing that we were supposed to meet every month or every 6 weeks, and that kind of fell apart. I would, if, with the permission of our Madam City Attorney, if there could be some directive that, you know, that there be a priority on this with the department heads, because there was difficulty getting these meetings together. We're happy to do it.
I got you, who's gonna take the leadership on this? I want somebody responsible to say, make sure that meetings take place, are they supposed to? You guys will do it?
Commissioner,
I know they're different departments,
Response.
somebody's gotta coordinate this.
we do not have a set of plans that have been submitted.
No, I understand that,
for construction for Helen.
and he understands that, he's gotta present that. But I want you,
Is the will of the board for them to go 2 different routes and to get helicopters landing and taking off? And Mr. Garcia said that there could be is it a bridge, exception, that they could be working on one, adding to the next? Because at the end of the day, a parking garage, a 5-story building does not have any influence on takeoff and flights. Most helicopters that I'm aware of, people take an Uber or their own private car service, drop off, and it goes. So the building really, for me, it's a beautiful rendering,
Thank you.
but it has no impact on
It's a little
getting
more
this
complicated
operating.
than that. It does in the big picture.
I'm good, I can read it. It's a request of the,
Should we, as a board, do we wanna have 2 separate
Separate
exceptions
board.
going on? And just get this going, because it's
Too far down.
based on the recommendation, of Mr. Garcia, of the building department that's here. What do you guys believe would be the best thing for what we're trying to do, which is land and take off helicopters as soon as possible?
So in an effort to assist, address the issue, what I can offer you are solutions, hopefully, and it is certainly an option for the applicant to proceed ahead with, again, first an abridged version of the project that allows them to operate sooner, especially if it facilitates the licenses they need to obtain from the FAA, etc. And then subsequently, the full-fledged project can be submitted through a separate exception process, each of which faces, I should add, will themselves have to go through the building permit process and fully comply with building code.
Can you show us any examples in the past where you've had a developer come to you in this scenario, where one has been approved and the second part has not been approved? Or are they usually approved one after another?
It is not so much a first part and a second part,
Okay.
it is, there are really two components, right? One is the operational component, which are the landing pads
Correct.
themselves, and then the ancillary building is a secondary component of the same project.
Okay.
It is for that reason that I think this project is ideally, again, not glossing over some other functional difficulties that I am sure attend this issue, but I will say that this happens to be a project that lends itself rather nicely for a two-step approach. One, the functional aspect of it, and then the building and accessory components.
So that's what we would like to do.
Well, if that's the case, you need to
Excuse
build
me,
in some
excuse me.
protection for us.
Excuse me.
Oh, I'm sorry.
Yes, ma'am.
I have a question. Assuming that the city went the route, that the gentleman went the route of exception one and then going on to two, would there be some very strong language that would go into whatever agreement or whatever, or, you know, approval you give for exception one to go forward, in the event that something would go wrong, whether it's through the first phase, or that when they get to the second exception, something occurs that they are not granted this, so that they cannot say that the city did not warn them. This, from what I hear, there's nothing certain about one or two. So I think it would be incumbent to at least be sure that if number one is, if this is the decision to go forward, that there be some very strong language in a caveat sort of way.
My understanding what he's requesting is, if he goes to phase one, he wants to make sure that he doesn't get penalized if the second phase did not pass. And that's what he's worrying about. So what he requests, if he uses what we're suggesting, or the board suggests, then that we have to make some changes or amendment later on if the case, the second phase is not passed. Am I correct?
Yes.
Yes.
Okay. What's the wish of the board?
Guys, are you in favor with the two-step process? Any comments?
I just keep hearing the word in my head, delay, 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 delay. I've been on this board 8 years. We've had the same discussion to the point where my eyes, I have to fight, you know, that film that comes over your eyes once you've heard a discussion about 30 times. Whatever expeditiously gets us a heliport is what I am in favor of. And if that is the requirement, as you were pointing out, that we create this very strong language in a caveat regarding phase two, but if we can get these phases moved along together, which would expeditiously get us a heliport, then let's do it. Stop talking about it.
Do I have a motion?
So moved.
Well, okay, it's been moved to the.
And the motion also is for them to meet with zoning,
No, that's
building,
gonna take place.
for the,
With
Yeah, but
everyone,
I need to have-
with everyone.
Commissioner Gordon,
There's no motion.
who's gonna fast track this from the administration?
I can do it.
He's gonna do it, he's gonna be in charge.
Say the motion.
He's gonna be the, make sure that all the meetings take place. Okay?
and then for the next meeting, we need an update that
What
that the
has
first phase has, hopefully, everything has taken. Because after that first phase has been approved, is when they have to go to FDOT or FAA for their license, correct?
Right.
Okay.
I
So
like,
you wanna start the motion?
well, I like Ms. Canton's caveats. Could you restate it in the form of a motion, which I'll move? Thank you.
That the language, that language be adopted, to be reviewed by the city attorney's office, as well as, independent counsel that the gentleman may choose, to basically, guarantee that there really is no guarantee that given exception one doesn't mean that you're going to get to exception two, and that the city basically would not be at fault if for whatever reason this exception two is not granted.
Who's gonna write the language?
But could I just comment?
City attorney.
Can we think this through for a second? Because they're under a development order that says they have to build phase one in so much time, phase two, which is the fuel farm, phase three. So if they, let's say they hypothetically get approval for the first exception, then they're still under the contractual obligations to get phase two and phase three done. So there are no guarantees or potential guarantees. They still have to go forward pursuant to the contract and get approval for
I think-
the more significant one is
I think it was well
So I
stated,
think-
I think it was well stated.
Well, my
He says if we go through first one,
Right.
he will recommend and we will request if it's denied phase two, that we make some amendments to the contract, which this board can do.
Okay, that's what,
Okay.
I missed the last part. All right, thank you.
Okay.
Jose Camero.
Second mayor is the one that's gonna be in charge.
In charge.
Do we want an update at the next meeting with where we're at?
I have a, I'm sorry, I have a question.
Yes.
Who's gonna provide me with the language and everything else?
The language, I understand what she's saying. I don't think that's really, there's not much they can do. They can do whatever language they can. My law department, working with the planning department, can come up with the language. But I don't think that language will really influence that much. What's gonna happen is, if phase two is denied, then they would have to come in front of this board to make some amendments to the contract.
Okay, so
Which is
we're
fair.
just gonna
Perfect.
leave it in the record.
All in favor?
Aye.
Thank you.
Thank you.
Cheers.
Thank you, Commissioner. And we have to move quickly. I know that Commissioner Gore has to leave,
As do I.
but we need to have the plans from the seaplane base. That was one of the purpose, actually, the purpose of the meeting. So who's going to speaking in terms of the plan for the seaplane base? The request of the board was, yes.
Well, at the last MESA, Marine came with the seaplane base. At the last MESA board meeting, we presented plans to every individual board member, and the directive was that the board members would review and decide in this meeting what to do about those plans. So we don't really have anything more to present on our side other than Mr.
With the understanding that the hotel was not allowed.
Well, the plans do not contemplate the hotel.
I would just like to say that in the last submission, that I was not here, we submitted, the plans, we removed from the plans all the areas that make reference to the lodging use. And we have limited the plans strictly to the air terminal facility and to what Judge Cueto ruled, that we had the right to construct in that air terminal facility, which was 15,681.6 square feet. I think it's something that it's unquestionable, and that we have the right to do that air terminal agreement with that, with those square feet of food and liquor service areas, and that's what we presented. And that's what we're expecting you to approve.
So, Madam City Attorney, you want to opine on this?
Well, right now, we have, I believe the board has a preliminary, super preliminary set of plans. If in concept you are fine with the schematics, not the uses, but the schematics and what, you know, it looks like to move forward, then the building department can continue processing that. We discussed the hotel uses.
We would have to go to planning first before going to building, because we have to go through the exception process.
That's fine, but it would be nice to, you know, continue working with everybody at the same time so that we don't have
Yeah, but
to
in
work
order to
in
do
silos.
that, in order to do that, the board has to approve the plan.
Right, the preliminary
The
plans
concept.
that have been, the concept and preliminary, super preliminary plans that have been submitted to you. So if this board is fine with that, sans the hotel, no hotel discussed right now, because we, you know, we agree at this time that a hotel is not, part of this process, so. I think that the board just needs to say whether they're fine with the preliminary plans that they have.
Okay, do we have any comment? Do we have a motion, to approve, disapprove? I would request if we can do a vote, because that way they know how to proceed.
I
Yes.
move that we approve the conceptual plans, provided that there will not now or ever be a hotel on that property. And I thought that was what was represented last time.
And that is
my motion.
represented now.
And that is represented.
Second.
Okay, we have a motion and a second.
Building
is-
department has not received anything either with regard to anything.
Right, they will because they can
You have
until.
to go through the exception first, so have the same procedure as the other person.
Madam City Attorney, this resolution as the structure by Mr. Solowski is binding, for the developer in terms of not trying to go an appeal, something to go to a hotel or something like that.
No, it's binding based on the contract and based on what this board, has agreed to for purposes of this project. I mean, that's what's being, discussed right now.
Okay.
Please, if I have, may I would like to discuss. As you all know, and let me read this because I would like to be sure that we all understand what we're saying here. Chucks has been attempting for several months now to obtain MESA's cooperation in the submission of our initial plans to the PSAP under the exception process, as required under the CI zoning designation. So far, MESA has refused to cooperate with Chucks in such regard on the basis that the CI zoning designation does not permit lodging uses, as just mentioned before. And so far, our position has been that MESA is not competent and has not been granted any authority in deciding upon zoning matters, which are the exclusive competence of the City Commission, the PSAP, the Planning and Zoning Department, the Planning Director, and the Zoning Administrator. Therefore, MESA should limit its actions and decisions within the contractual scope of our lease agreement, which in our opinion contemplates such uses as ancillary, related, and incidental uses to an airport facility. However, on May 2, Chucks decided to remove from its plans all areas contemplating such lodging use or any other commercial use not contemplated in the original sublease as a Phase 1 initiative, expressly contemplated in our sublease contract, by the way, in order not to delay any longer the construction of our facility. In this regard, Section 5.8 of our current sublease agreement expressly states the landlord agrees to reasonably cooperate with any request by tenant in connection with the zoning and landing use of the property to permit the use and structures contemplated in the original sublease and this sublease. Therefore, MESA has no legal grounds whatsoever to refuse to cooperate with Chucks in such regard if such plans are limited to the uses and structures contemplated in the original sublease. And in this regard, Chucks plans only contemplate the air terminal facility, which as ruled by Judge Cueto, may have food and liquid services areas of at least 15,608.6 square feet. And that's all we are respectfully requesting today.
Jay, you want to?
Yeah, it is, I believe, the unanimous opinion of this body that the contract, sublease, entered into between Chalks and us, the use clause of which does not permit a hotel use. That is our opinion. What you have read into the record does not specifically refer to the lease in that regard, but you're referring to zoning. That is not what governs your operation directly insofar as the lease is concerned. It was my understanding that you had agreed, based upon representation of Ms. Kim last time, that if we were to approve the plan, you would not seek to have hotel use on that property, period.
The representation made at that time, because I was on the other side of the phone, was that if you approved it at that meeting, and you didn't.
So you're going back on it?
No, I'm not going back. I'm just keeping what it was said. I'm just saying what it was said. I'm not saying that we have the right to a hotel because it's not within our competence of this board nor of us, because that's a matter that has to be decided by zoning.
No, we don't agree.
I'm sorry, sir.
No,
I'm sorry.
Wait.
Where did the contract say that? What you said?
Wait, no, because the city attorney has to opine on this, because this is an agency of the city, and we are the landlords of the land, and this board has authority to decide. Just and you will continue, but Madam City Attorney, again, my question is the resolution as presented by, Board Member Solowski binding?
As in, will this be appealed, can this be appealed to the city commission or something along those lines? That's what you're asking? Because at this time, the only thing that is here is for this board to accept these preliminary plans for, the seaplane base without a hotel component, because it is not allowed. And whether, Mr. Vega disagrees with that or not, unfortunately, that is the zoning at this time. That is the contract parameters. No hotel was contemplated. So right now, the only thing this board needs to address is whether or not they accept the plans as presented, preliminary, super preliminary plans as presented to have the seaplane base. A hotel is not an option here right now.
Can we add a covenant as to reaffirm what Mr. Solowski is saying in the resolution?
A
That
covenant that a hotel will not be a part of the seaplane base?
Right.
Sure. That could be.
And Mr. Mayor, if I can, first
Yeah.
of all, our plans right now do not make any reference to a hotel.
No, we understand that.
Secondly, they will never make a reference to hotel because we have never applied for a hotel. We have applied for a park hotel.
It's just that
But-
we are
but-
confused,
but I
we're
know.
confused because you said that this board does not have the authority.
No, what I'm
about the
saying, sir, is that this board could request the Director of Planning and Zoning to give his opinion as to whether we have or not, and have a legal opinion from them officially, and then we'll go for something else. But I think that what we have is the right to go through the process. In the same way that you're contemplating that an exception process could be denied because of other matters, as we just said before, I just want to go through the exception process and be denied, and then I'll go back.
Nacho, the only difference is if Dudley were here asking for a hotel for his
I know.
pilots, we would say no as well.
I know, but what
So
I'm
we wouldn't even go through that
What do you want,
process.
all?
I understand, but what I'm trying to say here is that the contract very clearly says ancillary related, and I think that we have already brought to this board.
But the city attorney is saying no.
Right, so I don't know, I guess we're speaking past each other. Hotel uses, not allowed, they're not allowed. Already zoning has, also opined, I mean, I don't know why we're beating a
No,
dead
because
horse.
it's not only apart hotel, is what I'm saying. We need lodging. Our security in the airports, I'm sorry, excuse me, our security in the airports, need that we have some spaces for the security to stay there at night, for example, which is lodging as well. So it's not that we're asking for all of that.
Marine King with the Miami Seaplane Base. So the city attorney's position is that there are no legal instruments available to Chalks to pursue this matter, correct?
I'm sorry, say that again?
So the city attorney's position is that that Chalks has no legal instruments with the support of this board to pursue this matter, correct?
To have a hotel,
Yes, so let me.
to have a
yes.
hotel?
No, to
not a
approve the
hotel.
lodging use. Yes or no?
No lodging,
Okay,
no hotel.
So since we have the planning and zoning departments here, just so we are all very clear, there is no legal instrument like an interpretation, a determination, an ordinance changing the definition of the zoning code because there's an inconsistency with the comprehensive plan. None of those are options because I believe that we have not had the chance to have this conversation, Ms. City Attorney. On April 17th, we were supposed to meet with you and the planning and zoning departments, and your office set up a meeting to which only Mr. Weislang showed up, precisely to have this conversation so that we would have both the city attorney and the planning and the zoning departments together to discuss the feasibility. We're not asking this board to approve or deny that. We're asking the board to give a directive to the city to allow us to at least have the conversation to see if we have that option. And while we parallel that, we're asking for approval for a first phase, which would be what is contractually given to us, not just by right, but by a court settlement in 2013 with Judge Cuadros. That is what we're presenting.
So you're going to continue to ask for a hotel? Is that your position?
No, what we're trying to say is we think we have to table that conversation, but that should not determine whether my first phase gets approved or not.
Exactly. I mean, what
No,
Mr. Solowski said.
Wait 1 second. Listen, we are about to lose quorum. So we can continue this conversation, or we can vote before, Commissioner Gore really has to go, Nathan really has to go, we will lose quorum, and then, there is no vote on the plan. And,
Mr. Mayor, we want you to vote, but we do not want to concede to a condition that would forever
then you
banish
know,
a lodging
then,
use from a
you
major
know,
transit
we-
facility.
we
That's
will
incorrect.
lose-
That's
we
just
will
inappropriate.
lose-
It's
If we
not
lose
prohibited by
quorum,
law.
if we lose quorum, we will not be able to vote on this meeting, and we have to convene another meeting.
Mr. Mayor? Hi, it's Rick.
One second.
ahead.
Ms. Canton, very briefly, because we have to decide if we want to vote. And Madam City Attorney, the resolution that, Mr. Solosky has proffered, seconded by Commissioner Ward, specifically, says that the plans are approved without, a hotel. And I know what they're gonna say, that, this is a preliminary, plan. But, the authority of MESA has been questioned in terms of, there might be a hotel because they might go around to PCAB and the city commission. So we just to clarify, but.
Mr. Mayor, thank you. I think my feeling is that you have heard the will of one board member, and you should take a vote upon that motion that has been made, as it is on the table. I think it is pointless to have a legal argument at this meeting. This is not a court of law. I think that what you have before you is a simple question on a motion that has been.
No, but the motion, okay, I keep asking, the motion, it has something on it that makes uncomfortable,
That's fine. But
the people. So if we proceed, it's fine, just, I was just asking the city attorney whether this motion is binding for everything,
It's
in the
binding,
future.
you're the landlord. You
Okay.
know what you want to do on your
So-
property, what's allowed by the contracts at this time.
They can appeal later on.
Okay, so we have a motion and a second on this, resolution. Would you, again,
Say it again.
Mr. Solosky,
Say it
repeat the resolution?
I move that we approve the conceptual plans as provided by Chalks with the understanding that there is no hotel now or ever on this property.
Okay, that was seconded by Commissioner Ward. All in favor, say aye. Aye. The motion passes unanimously. Okay, thank you. We're losing quorum. However, we have one non-voting, item that we need to just, report, and it's a result, of,
Mr. Mayor, I'm sorry, just for the record, we would like to object on behalf of Nautilus to that condition proffered by Mr. Solowski as an interference with our contractual rights under the agreement. Thank you.
okay, it's on the record, and, resolution, is official, so they can move forward to, Mr. Camero, then next is,
Next step, I'll get together and with planning and establish a deadline, a timeline, and try to move those meetings.
thank you very much, Mr. Bill. Yes, gentlemen, just for, to clear the record, on the Arturo Campa, the money for the Jazz Festival, the check has been returned as per, board direction. The $10,000 will be remitted to the other, recipient.
We have been made whole then.
Yes, yes, ma'am.
I remember that inspection.
Thank you very much.